Imagine a scenario where in the spur of a moment you take a rash decision and a reckless action based on that decision. You also pay the price for it in the form of appropriate judicial sentencing and serve your punishment. And yet you think that it's all over and nobody is going to remember it after a few years. Until one day you just Google search your name and then suddenly those unpleasant memories flash back because all those details about those incidents are right there online. People can simply type keywords related to you and can know about the unsavory incidents that once happened. This is exactly what happened to Ashutosh Kaushik, the winner of the reality shows Roadies 5 and Bigg Boss in 2008. In fact, last year, he approached Delhi High Court with a petition related to right to be forgotten. In his petition, he is seeking to have all internet content related to his various sensitive incidents, including a 2009 drunken driving incident and an altercation at a Mumbai cafe in 2013, to be removed from the internet. There are also dozens of other similar petitions lying pending with various high courts in the country. Today, we will look at this newly emerging concept of rights in the domain of the digital world and what courts stand on it have been so far. As the phrasing speaks for itself, the right to be forgotten simply means having unpleasant incidents, description of them completely expunged from the realm of virtual world after one has paid the legally mandated price for it. It entails removal of every link and news related to those incidents so that nobody stumbles across it if they try to search it on Google, Bing or any other search engines. They basically want to be forgotten virtually, especially for search results that continue to tarnish their reputation by cropping up time and again. This is a relatively new concept in India and is yet to gain traction or wide recognition even among the general public. So, does this mean that the right has already been recognized in other nations and is on other statute books? The answer is yes. There are several nations which have already recognized it. In 2015, Russia enacted a law that allows users to force a search engine to remove links to personal information on grounds of irrelevancy, inaccuracy, and violation of law. This right is also recognized to some extent in Turkey and Siberia, while courts in Spain and England have ruled on the subject. In the European Union or EU, the right to be forgotten empowers individuals to ask organizations to delete their information and personal data. It is provided by the provisions of the EU's General Data Protection Regulation or GDPR, which is a law passed by the 28-member bloc in 2018. And in its landmark ruling, the EU's highest court ruled in the 2019 that the right to be forgotten under European law would not apply beyond the borders of EU member states. This ruling was an important victory for Google as it laid down the online privacy law cannot be used to regulate the internet in countries such as India, which are outside the EU. In India, although several petitions have been filed, only a few have managed to get some relief. In May of 2019, Delhi High Court, dealing with a civil suit seeking removal of certain news reports on Me Too allegations against the managing director of a media house, said that the right to be forgotten and the right to be left alone are inherent aspects of the right to privacy and restrained republication of these news reports. Then, in April of last year, a woman sought the removal of a matrimonial dispute-related information. The court ruled in her favor, but Google had challenged that decision. In January of 2017, the Karnataka High Court ordered its registry to ensure that any search engine does not reflect a woman's name in an order passed by it in 2015. Although the concept is still evolving in India, it has been considered to be an aspect of right to privacy which has already been recognized as a fundamental right in the famous K.S. Puttaswamy judgment of 2017 by the Apex Court. Go ahead and Google K.S. Puttaswamy judgment of 2017 right away. According to the government, the provisions related to the right to be forgotten are not in the IT Act but have been enumerated in the Data Protection Bill, which is yet to become a law. This was all about an evolving domain of rights that is likely to gain more currency in the coming days with the changing technological landscape for our country. We hope you like this information about a vital aspect of online privacy. Thanks for watching.
Subscribe to Oneindia channel and never miss an update.